help related. We award and monitor competitive grants for fair housing organizations. And we advance environmental justice and enhance economic opportunities for low-income populations. So these are just a few of our core important responsibilities that our office performs. So what are the laws that we actually enforce here in the Office of Fair Housing and Equal Opportunity? Well, there are four major laws. And the first one is the Fair Housing Act, or otherwise known as Title VIII of the Civil Rights Act. I'm sure many of you are familiar with the Fair Housing Act. We also enforce Title VI of the Civil Rights Act of 1964. We enforce Section 504 of the Rehabilitation Act of 1973. And Section 109 of Title I of the Housing and Community Development Act. So what do these laws do? Well, I'll start with the Fair Housing Act. So the Fair Housing Act prohibits discrimination in a number of areas. So on this slide here, I've kind of captured a few of the more important areas that it covers. But it prohibits discrimination in the sale and rental of housing, and that includes the terms and conditions that are associated with that sale or rental. It prohibits discrimination in mortgage lending, which includes insurance-related issues related to the lending, as well as property appraisal issues. It prohibits discrimination in advertising. It requires housing providers to make reasonable accommodations and modifications for persons with disabilities. It requires newly built multifamily dwellings to contain certain design and construction features so that they're accessible for persons with disabilities. And it prohibits retaliation against an individual if they have filed a complaint under the Fair Housing Act or if they've exercised their rights under the Fair Housing Act. So those are just kind of a broad overview of the protections under the Fair Housing Act. The second statute that we enforce is Title VI of the Civil Rights Act of 1964. And this makes it illegal to discriminate on the basis of race, color, and national origin in programs and activities receiving federal financial assistance. The next law that we enforced was Section 504 of the Rehabilitation Act of 1973. And this law forbids discrimination on the basis of disability in programs and activities receiving federal financial. And finally, we have Section 109 of Title I of the Housing and Community Development Act. And this law makes it illegal to discriminate on the basis of race, color, national origin, sex, and religion in any program or activity that's funded either in whole or in part by Title I of the Community Development Act of 1974. And this would include community block grants. So that's kind of in a nutshell is a summary of what we do in the Office of Fair Housing and Equal Opportunity. Now I would like to focus on the priorities here at HUD and in the new administration that are related to fair housing. So the first priority of this administration is a priority to address the deep inequities and systemic racism that continues to plague our nation. Neighborhoods remain racially segregated today, despite the Fair Housing Act being passed over 50 years ago. And that segregation directly contributes to unequal access to quality schools, healthcare, transportation, employment opportunities, and much, much more. People of color, especially Black Americans and Native Americans, experience homelessness at a much, much higher rate than white Americans. The gap in home ownership rate of Black Americans and white Americans is larger today than it was 50 years ago, and is the leading reason why the average Black family has a fraction of the average white family's wealth. People of color are nearly twice as likely to live in close proximity to major sources of air and water pollution. Central to HUD's mission of promoting fair housing is ridding the nation of housing discrimination and overcoming the lack of fairness created by decades of systemic inequitable policies. As a nation, we are finally confronting some of the most difficult issues that have persisted for too long. And HUD, as well as the new administration, is working tirelessly to promote equity and vigorously fight for the rights of the underserved communities. On January 20th of this year, President Biden issued an executive order on advancing racial equity and support for underserved communities. On day one of this administration, they began the work and demonstrated its commitment to working with communities to end housing discrimination, to redress the ongoing harms of racist housing policies, to remove barriers that restrict access to housing and neighborhood choice, and to secure equal opportunity or access to equal access to housing opportunities for all. On January 26th of this year, President Biden issued a memorandum on redressing our nation's and the federal government's history of discriminatory housing practices and policies. In this memorandum, President Biden specifically directed HUD Secretary to examine the last administration's August 7, 2020 rule entitled Preserving Community and Neighborhood Choice, which repealed the Obama-Biden administration's Affirmatively Furthering Fair Housing rule and otherwise ended effective enforcement of the requirements of affirmatively furthering fair housing. So on June 10th of 2021, HUD published an interim final rule on affirmatively furthering fair housing. The interim final rule did several things. So first, it restored many of the key definitions of the 2015 Affirmatively Furthering Fair Action Rule. Second, it restored the certification requirements. So under the restored AFFH regulatory definition, HUD program participants must certify that they take meaningful action to address significant disparities in housing needs and in access to opportunity, replacing segregated living patterns with truly integrated and balanced living patterns, and transforming racially or ethnically concentrated areas of poverty into areas of opportunity, and fostering and maintaining compliance with the civil rights and fair housing laws. And then finally, the interim rule rescinded the 2020 Preserving Communities and Economic Choice rule. This final interim rule went into effect on July 31st of this year of 2021. So what are the next steps? Because the interim rule is just that, it's an interim rule. So first, HUD plans on designing a new, more comprehensive affirmatively furthering fair housing rule. This rule will be crafted to implement a fair housing planning process that will be less burdensome for both program participants and HUD, and more focused on ensuring that the program participants make progress on their commitments to meaningfully further fair housing. In addition, HUD has restored to its website the guidance and resources available for program participants' use in conducting fair housing planning. These resources include the AFFH Rule Guidebook, the Fair Housing Planning Guides, the AFFH Data and Mapping Tool, and assessment tool for local governments and the assessment tool for public housing agencies. So you can see that the administration has already begun its commitment to these issues, and HUD has begun the work of implementing many of the president's orders. Another priority is the elimination of barriers to opportunities and benefits in federal programs and services for people of color and other underserved groups. The president has ordered HUD to determine how to redress our nation's and the federal government's history of discriminatory housing practices and policies, and we are working on doing just that. This will require us to work with our stakeholders who will play a critical role in ensuring that we are undertaking and meeting this challenge. Another priority is protecting against discrimination on the basis of sexual orientation and gender identity. In February, HUD was the first federal agency to implement the president's executive order on preventing and combating discrimination on the basis of gender identity and sexual orientation. HUD issued a memorandum stating that the Bostock Supreme Court decision extends to the Fair Housing Act's prohibition on discrimination because of sex. And HUD, for the very first time, took the unparalleled step of adding protections for lesbian, gay, bisexual, transgender, gender nonconforming, and queer individuals when trying to find a place to call home. Later in my presentation, I'm going to talk a little bit more in depth about what HUD is doing to protect the housing rights of individuals based on their sexual orientation and gender identity. Another priority is strengthening fair housing enforcement. HUD recognizes the importance of eliminating racial bias and other forms of discrimination in every stage of the home buying and renting process, and lifting the barriers that restrict housing and neighborhood choice and ensure that the sufficiency of availability of accessible housing. In order to do this, HUD needs to have the staffing and the resources in order to carry out this mission. And this administration is committed to making sure that those resources are provided. I am happy to report that the Office of Fair Housing and Equal Opportunity should end the federal fiscal year this year with around 600 employees. And this is up from about 400 employees from several years ago. And more staff is expected in the new year. But HUD can't do it alone. We recognize the importance that the roles of our FAP and our FIP partners play in this process. So in addition to being committed to make sure FHEO is fully funded and staffed, HUD is committed to supporting our FAP and FIP programs as well. Last year, HUD and its FAP partners received, I should say, more than 7,700 complaints alleging discrimination based on the Fair Housing Act's protected classes. And anecdotal evidence suggests that many other instances of discrimination have gone unreported, so the number of cases probably exceeds that. So I've talked a little bit about the priorities of the new administration. Now I want to go over the FAP and the FIP program because they're instrumental partners of HUD in accomplishing a lot of those priorities. So first, I want to start with giving you a little bit of an overview on the FAP program. So under the Fair Housing Assistance Program, or what we call the FAP program, the department can enter into cooperative agreements with state or local agencies if those state or local agencies enforce a law which is substantially similar to the Fair Housing Act. So what does it mean to be substantially equivalent? Well, in order to be substantially equivalent, the FAP agency's law must be substantially equivalent in 4 areas. The first area is substantive rights protected by the law. The second area is procedural process. The third area is remedies. And the fourth is availability of judicial review. So what do these mean? So let's start with substantive rights protected by the law. What that means is that the state or local government's law must be substantially equivalent in the substantive rights that are protected under the Fair Housing Act. So that would include the bases of protection in the Fair Housing Act. The Fair Housing Act's 7 protected bases must also be protected under the state law. And the scope of the protections must be substantially similar. So previously, I had gone over the scope of the Fair Housing Act and that it prohibits discrimination based on the sale or rental, that it prohibits discriminatory advertising, and it requires reasonable accommodations and modifications. So all of those protections that are contained within the Fair Housing Act must also be protected in the state or local law. So the substantive law, in terms of the scope of the protections, must be substantially similar. Procedural process. What that means is that procedurally, the laws must operate in substantial similar way. And the state or local law can't impose additional burdens on a complainant to exercise their rights under the law as the Federal Fair Housing Act does. So procedurally, the process has to be substantially similar. Third, remedies. The remedies available under the state or local law must be substantially similar to the remedies available under the Fair Housing Act. And then finally, the availability of judicial review. And what that means is that under the Fair Housing Act, a complainant has the right to file in federal court, regardless if they file with HUD, and that time period to file in court is going to be told while an administrative process is pending. And so those same rights have to also exist under the state or local law. So if a jurisdiction has a FAP agency, the department will enter into a cooperative agreement with that agency and dual file complaints filed with that agency and refer those complaints to the FAP agency for investigation. So who are our FAP agencies in the state of Indiana? The state of Indiana has 7 FAP agencies who have cooperative agreements with HUD. We have 1 state FAP agency and 6 local government agencies. So first we have the Indiana Civil Rights Commission, who is our state FAP. Then we have the 6 local government FAPs, and those include the Fort Wayne Metropolitan Human Relations Commission, the City of Elkhart Human Relations Commission, the City of Evansville Vanderbilt County Human Relations Commission, the City of Gary Human Relations Commission, South Bend Human Rights Commission, and the Hammond Human Relations Commission. So HUD has cooperative agreements with all of these agencies. So if we were to receive a complaint involving a violation that occurs in one of those jurisdictions, we would refer that complaint to that agency for investigation and processing. Pursuant to the cooperative agreement, HUD provides funding for our FAP agencies partners. And that funding generally falls into 3 different buckets. The first bucket is funding for case processing, which reimburses the FAP agencies for investigations that it actually conducts. The second bucket is for training. We provide funds to allow the FAP agency to train their staff in fair housing. And then the third bucket involves administrative costs funds. And so these funds are designed to defray some of the costs of maintaining a fair housing program. So defray some of the administrative costs of that program. But in addition to those 3 buckets, periodically, HUD will make available partnership funds for its FAP agencies. And these funds are designed to allow a FAP agency to enter into a partnership project with a local entity or local FIP agency or organization to accomplish a stated purpose that's set forth in the partnership funds requirements. So what were the purposes for which partnership funds can be used for the 2021 funds? So there are 4 main different purposes with which FAP agencies can apply to use those funds. And the first is to address issues because of discrimination, especially because of, discrimination because of sex, specifically because of sexual orientation and gender identity, and to educate the community regarding the protections for sexual orientation and gender identity under the FAIR Act and the jurisdictions locally substantial equivalent law. The second purpose could be used to address discrimination because of race, which would include discrimination against Asian Americans and Pacific Islanders, Black, Indigenous, and other communities of color, and racial biases that restrict housing, neighborhood choice, and integrated communities. The third purpose that a FAP agency could propose to use those funds for are to address fair housing issues related to the COVID-19 pandemic. And then finally, the FAP agency could petition to use those funds to address fair housing issues resulting from or connection to the lifting of the eviction moratoria. So now that I've given you kind of an overview of the FAP program, I want to share with you some of the statistics involving cases that were filed and handled in the state of Indiana in the last case processing year. So for those of you who may not be aware, A typical case processing year runs from July 1st through June 30th of the following year. So the statistics that I have displayed in the slide here shows the statistics for last year's case process, or actually this year's case processing years, 2021. And so this reflects cases that were filed between July 1st of 2020 through June 30th of 2021. And I know this slide may be difficult for you to see if you're viewing it at home, but I'll highlight some of the features of the statistics that are displayed here. So first, there were 269 fair housing complaints filed that involve violations occurring within the state of Indiana. Of those 269 cases, 231 are being handled by our FAP agency partners, and 38 are being handled by HUD directly. In terms of the protected bases that these complaints involve, the most, or the highest number of cases we're seeing is involving disability discrimination. So 110 of those complaints had an allegation of disability discrimination. Race was a close second. 105 of those complaints involved an allegation of race discrimination. The next highest was sex discrimination, which involved 48 cases, and another 4 involved sex related to specific LGBT issues. Next came familiar status discrimination. 35 of those cases involved familiar status. And then 16 involved national origin discrimination, 13 involved discrimination based on color, and then 1 involved discrimination because of religion. Now, if you do the math and if you add up all of the different protected categories, you see that's going to be far more than 269. And the reason for that is because one complaint could have multiple bases alleged in it. So we could have a complaint that alleges race, national origin, and color. That would be one case filed, but it would be 3 different protected bases. So that kind of gives you a snapshot of the types of cases that were filed in the state of Indiana. So now I want to flip to my next slide here, which shows cases that were completed during the case processing year. So these are cases where the investigation was completed between July 1st of 2020 and June 30th of 2021. So you see from this slide that there were 238 cases completed. Of that, 215 were completed by FAP agencies and 23 were completed by HUD. Of those cases, 16 were cases where charges were issued. So there was a finding of probable cause of violation and a charge of discrimination was issued. 40 involved conciliated agreements, so cases that were settled pursuant to a conciliation agreement. 12 were cases that were withdrawn because a private settlement was reached between the parties. And the remaining cases were either closed for lack of evidence or for administrative reasons. You will see from the slide that 141 of the cases were closed within 100 days of filing. So that correlates to roughly 59%, which is far above HUD's goal of 50%. So you will see that our FAP partners in HUD are not only busy investigating cases, but we're maintaining those investigations and completing those investigations in a timely manner. Now that I've talked a little bit about the FAP program, I want to turn and give it a little bit of an overview of the FIP program. So under the Fair Housing Initiatives Program, or FIP program, HUD provides grant funding to private fair housing agencies to carry out education, training, testing, and local fair housing enforcement and investigation and advocacy activity. So this year in FY 2021, HUD has made available over $47 million in grant funding for our FIP agencies. And this funding is broken down into 3 different types of grants. There's the Private Enforcement Initiative grants, otherwise known as PEI grants, or the Education and Outreach Initiative grants, or EOI grants, And then there's Fair Housing Organizations Initiative grants, or FHOI grants. So this year, HUD has awarded over $34.5 million in private enforcement initiative grants. These grants are awarded to organizations to conduct intake and testing and to investigate and litigate fair housing complaints under the Fair Housing Act. Additionally, HUD has granted a little over 10.7 million in education and outreach initiative grants. These grants are awarded to organizations that educate the public and housing providers about the Fair Housing Act. These grants will also support state and local organizations that seek to enhance fair housing laws that are substantially equivalent to the Fair Housing Act. And finally, HUD had awarded over 2.1 million in Fair Housing Organization Initiative grants. These grants are awarded to help build the capacity and effectiveness of nonprofit fair housing organizations, particularly organizations that focus on the rights and needs of underserved populations that include rural and immigrant populations. In Indiana, we have one FIP agency, and that's the Fair Housing Center for Central Indiana. So in addition to funding our FIP and FAP program, HUD also funds the National Fair Housing Training Academy, otherwise known as NAFTA. So the National Fair Housing Training Academy is the nation's premier initiative focused squarely on building the knowledge, skills, and capacity of HUD's FIP and FAP organization partners. So in the early 2000s, HUD had re-imaged the Fair Housing Training Academy. So for those of you who may have been familiar with the old academy, which was housed in Washington, D.C., and provided more or less in-person classes, both in Washington, D.C. and periodically throughout the country. Well, last year, the academy has been re-imaged so that the academy is deeply grounded in the needs and the wisdom of fair housing practitioners in the field and is dedicated to those working to end housing discrimination in communities across the nation. So the Fair Housing Academy's curriculum is largely being offered right now because of the pandemic virtually and for no cost. So on this slide, I have a link on HUD Exchange website for the National Fair Housing Training Academy. If you haven't done so already, I would encourage you to visit the website and to check out all of the useful information as well as the training opportunities and other educational opportunities that's available. I have highlighted here on the slide 2 of the up and coming events that are being sponsored by the National Fair Housing Training Academy. Next week, they will be having a course on the basics of fair housing. And then in the first week of October, they'll be holding the course related to litigating fair housing cases. And these are just 2 of many courses that are offered by the Fair Housing Training Academy. So I really want to emphasize and encourage you to check out this resource. It's an excellent resource. There's a lot of useful information, a lot of useful trainings. And like I said, right now, the courses are being offered virtually as well as for no cost. All right, now that I've talked a little bit about the Office of Fair Housing and Equal Opportunity and HUD's priorities related to fair housing and our relationship with our FIP and FAP partners, I want to now focus on talking more in detail on the fair housing protections for the LGBTQ+ community. So in 2020, the U.S. Supreme Court held in the case of Bostock versus Clayton County that the prohibitions against sex discrimination in the workplace contained in Title II of the Civil Rights Act extends to and includes discrimination on the basis of sexual orientation and gender identity. So essentially, what the Supreme Court found was that a person's sexual orientation or their gender identity is so intertwined with their sex that to be treated differently based upon their sexual orientation and gender identity is treating that person differently because of their sex. And therefore, it's covered under Title VII of the Civil Rights Act, which is the employment discrimination statute, federal employment discrimination statute. So the president, on his very first day in office, made clear that his administration will prevent and combat discrimination on the basis of gender identity and sexual orientation. And relying on this landmark decision in Bostock, he issued Executive Order 13988. This executive order directed every federal agency to assess the agency's actions taken under federal statutes that prohibit sex discrimination and to fully enforce those statutes to combat discrimination based on sexual orientation and gender identity. And we are proud that HUD was the very first federal agency to implement President Biden's executive order on this topic. After reviewing the provisions of Title VIII, HUD has determined that the Fair Housing Act sex discrimination provisions are comparable to those of Title VII, and therefore they likewise prohibit discrimination based on sexual orientation and gender identity. So on February 11th of 2021, HUD issued a memorandum stating that the Bostock Supreme Court decision extends to the Fair Housing Act provision on discrimination because of sex. So what did that memorandum do? Well, the memorandum did a number of things. So first, it stated effective immediately, the Office of Fair Housing and Equal Opportunity will accept for filing and investigate all complaints of sexual discrimination, which includes discrimination because of a person's gender identity or sexual orientation. So as of February, anyone who believes that they were a victim of discrimination based on their sexual orientation or gender identity can file a complaint based on sex discrimination with HUD. We will accept that complaint. We will investigate that complaint. And if there's a finding of cause of a violation, we will issue a charge and litigate that complaint as well. Secondly, the memorandum indicated that in order for a FAP agency's laws to remain substantially equivalent to the Fair Housing Act, they must administer their law consistent with Bostock. So if you remember, previously I talked about the requirements of the FAP program, and that the basic requirement is the FAP agency's laws has to be substantially similar to the Fair Housing Act. And one of those requirements that I mentioned was it has to be substantively similar. So in this memorandum, HUD has indicated that in order for the FAP law to be substantially equivalent and to be consistent with the Bostock decision, it has to do one of two things. So the state or local law must either explicitly prohibit discrimination because of gender identity and sexual orientation, or two, it must include prohibitions on sex discrimination that are interpreted and applied to include discrimination because of gender identity and sexual orientation. So either the law has to explicitly prohibit discrimination based on sexual orientation and gender identity, which some FAP's laws had already done that. But if they didn't, then the FAP agencies has to interpret their law to include sexual orientation and gender identity in the same way that HUD is interpreting the Fair Housing Act. Third, the memorandum indicated that organizations and agencies that receive grants through HUD's FIT program, in carrying out those activities under their grant agreements, they must interpret sex discrimination under the Fair Housing Act to include discrimination because of sexual orientation and gender identity. Additionally, in addition to requiring both the FIP and the FAP agencies to accept discrimination complaints based on sexual orientation and gender identity, HUD also mandated the Office of Fair Housing and Equal Opportunity and the FAP agencies to go back and search its records for the past year, and this is past year effective in February, to determine whether there were any sexual orientation or gender identity complaints, which would be now jurisdictional, but were not accepted for filing at that time, and to go back and to see if the complainant is still interested in pursuing that complaint. In addition to fully accepting and investigating complaints based on sexual orientation and gender identity, HUD, as I previously mentioned, had made partnership funds available and specifically indicated one of those purposes that those funds could be used for is to help address discrimination because of sexual orientation and gender identity, and to educate the community regarding these protections. All right, so the last area that I really want to spend some time on is talking a little bit about COVID-19 related issues. So the COVID-19 pandemic has shed light on the longstanding disparities in housing that I've previously discussed, and in turn have exacerbated the disproportionate economic and health impacts that the pandemic has had on certain communities. We have seen communities of color being disproportionately affected by COVID-19. We're seeing them having higher rates of infection. We have also seen them having higher rates of death or serious illness. We have also seen a spike in the cases of discrimination stemming from COVID-19 related issues. And I'll address some of these issues that we're seeing next. And then finally, it has created an eviction and foreclosure crisis. Many people were put out of work because of the pandemic, resulting in millions of people falling behind in their rent and their mortgage payments. While the CDC and state and local governments provided temporary reprieve from evictions through enacting eviction moratoriums, now that those moratoriums are expiring, the number of people who are facing eviction and potential homelessness is staggering. So in terms of the types of cases we're starting to see, or we've been seeing over the past year or so involving COVID-19, I want to talk about 4 basic areas where we're seeing influx of cases. So the first has to do with national origin and race discrimination. We have to be vigilant about the unwarranted and unacceptable rise in discrimination, hate, and violence against Asian Americans and Pacific Islanders, in part due to this heinous rhetoric surrounding the pandemic. And I want to assure to everyone that HUD will investigate any housing-related discrimination based on national origin. We are seeing cases coming in that involve tenants who are being denied housing because they may be Asian American or the national origin may be from China, either because of a hostility towards the COVID-19 pandemic or for fear that they may be more susceptible to COVID-19. We've seen an increase in the number of harassment allegations. So this is an area of concern. The second area of concern that we have relates to reasonable accommodations. Many persons with disabilities face discrimination because of barriers that prevent them from accessing housing or housing-related programs, including being denied accessible units that they might need to fully and safely enjoy their home. And so housing providers have an obligation to make exceptions to their policies, rules, and practices, and to allow persons with disabilities to make modifications to the properties so that they could fully and equally enjoy the property or their housing. And unfortunately, in regards to COVID-19, we've seen a spike in the number of failure to accommodate cases. And so one of the areas where we've seen a spike is that in response to the pandemic, we've seen a number of housing providers who have enacted policies or practices to try to address the pandemic. So we've seen policies which restrict access for tenants to guests or to visitors to come onto the property. And while these policies may be well intended, the housing provider may be trying to limit the spread of the pandemic, but policies like this could have a negative effect on a person with a disability. So for example, there may be tenants who have a disability which require them to have access to a home healthcare worker. Well, if the housing provider is denying access to visitors and guests and that's being applied in that circumstances, then that could have a negative effect on a person with a disability. Similarly, there may be persons with disabilities who need cleaning services to help them maintain their unit. They may need someone to come in and to cook for them or to do their grocery shopping for them because of their disabilities. And so these policies, if they're enforced without exception, could present a fair housing issue. In other areas similar to that, as we've seen housing providers enact policies that restrict common areas and elevator usage. And there may be tenants who have mobility impairments that need to use the elevator to access a second or third or higher floor unit. And so these policies could have the same effect of negatively affecting persons with disabilities. We have also seen an increase in the number of failure to accommodate cases where persons with disabilities are requesting accommodations to get more advanced notice for when a housing provider is going to access the unit, either for inspection, to make repairs, or et cetera. And these cases tend to involve tenants who have a disability that makes them more susceptible to COVID-19. So they're at a higher risk of infection. And so they're requesting that they either get more advanced notice so that they can take the appropriate steps to protect themselves, or if it's a non-essential inspection or non-essential visit to the property, that it be temporarily put off until after the pandemic. So we're seeing a number of failure to accommodate cases involving issues like that. And then lastly, we're seeing some cases involving persons with disabilities who are requesting longer time to move because of the pandemic. It's more difficult to find accessible housing or housing in general. So they need more time to leave. So those are some of the types of failure to accommodate cases we're seeing related to the pandemic. Next, I want to talk a little bit about familiar status. So we've been receiving a number of complaints alleging that housing providers have denied housing to persons who they believe are more associated where COVID-19 may be prevalent. And I kind of mentioned that already in regards to race, where landlords may not rent to someone based on their national origin because they may be from China. And we're starting to see the same thing true regarding familiar status. So we're seeing that there are some landlords out there who are reluctant to rent to families with kids because they believe that kids pose a higher risk for COVID-19 because they don't believe that children have the wherewithal to maintain social distancing and mask requirements. So we're seeing an influx of cases like that as well. And then lastly, I want to talk a little bit about sexual harassment. So I think everyone would agree with me that no one should have to endure sexual harassment or degrading treatment in order to keep a roof over their head. And HUD has devoted significant resources to protecting the rights of individuals to feel and be safe where they choose to live without having to endure degrading sexual harassment or unwanted sexual advances. This includes individuals, particularly women, who continue to have their housing conditioned upon consenting to unwanted sexual advances, even as the COVID-19 pandemic makes it more important than ever to have a safe, secure place to live. And the concern that we have is that generally victims of sexual harassment are tenants who may be in a vulnerable position. So there may be tenants who may have poor credit, or they may have eviction on their record, which makes it very difficult for them to find other housing. And so that makes them much more receptive to sexual advances being made by a housing provider. And the concern we have is, we're seeing an increase in the number of sexual harassment cases. And a lot of that is due to the fact that under the pandemic, you have a lot more people who are in much more vulnerable position in their housing. They may be behind in the rent because their income has either gone down or they've been laid off from work. They may be vulnerable because there aren't a lot of other housing options available to them because of the pandemic. And so they're in a much more vulnerable state. So, so we're concerned about the number of cases that we're starting to see or that we have been seeing regarding sexual harassment as well. So those are a few of the spikes in cases that we've seen so far. There are many other cases which have come into our office, which may be related to COVID-19 that isn't directly connected, but as a result of it as well. So what is HUD doing in response to COVID-19? So HUD is working to make sure that no one is unfairly denied housing because of COVID-19. Even as the nation is dealing with the public health crisis, unlike the world has experienced in recent times, HUD's mission will endure, and equity throughout recovery will be a top priority. HUD has taken steps to address discriminatory housing practices and policies associated with COVID-19. We've issued guidance to our FHIP and our FAP agencies pertaining to how they can use their HUD funds to carry out COVID-19 related enforcement activities. Last year in 2020, HUD awarded more than $40 million in grants to FHIP and FAP organizations, some of which could be used to support their efforts to address housing discrimination that is occurring because of the global pandemic. In 2020, FAP agencies were also awarded $1.5 million in partnership and special enforcement funds through the CARES Act to support COVID-19 educational activities. And as I mentioned previously, in this year, in FY 2021, HUD made available partnership funds, and two of those purposes specifically were related to COVID-19. One, addressing discrimination because of race discrimination, national origin discrimination, to address hostilities towards Asian Americans and others, and also to address specific fair housing agent issues related to the COVID-19 pandemic. In addition to the partnership funds, HUD announced in July of 2021 that's making $19.4 million available to help HUD's FIP agencies conduct activities that will address housing practices related to the COVID-19 pandemic. The funds, which were provided through the American Rescue Plan Act of 2021, or ARP, will allow private housing enforcement organizations to respond to fair housing inquiries and complaints, conduct fair housing testing, and implement education and outreach activities related to COVID-19 pandemic. These funds can also be used to address fair housing issues affecting individuals and families experiencing housing instability, including those who may face displacement due to discriminatory evictions and foreclosures. These ARP funds may also be used by fair housing organizations to equitably expand housing enforcement services for underserved populations who need their services the most. Underserved populations include individuals making fair housing complaints who come from low-income backgrounds and persons with disabilities, as well as people of color, including African Americans, Hispanics, Asian Americans, and Pacific Islanders. So in addition to the funds that HUD's making available, HUD's also taken a number of steps to fight the eviction crisis. And so the first area of activity for HUD is fighting unfair evictions. And as I indicated previously, HUD has made over $19 million available to fair housing partners to help them respond to possible fair housing violations, many of which are related to the pandemic and evictions. Second, HUD is providing resources for legal assistance. So HUD is making $20 million available to nonprofit and government entities to provide the availability of legal assistance at no cost to low-income tenants at risk of or subject to evictions. Keeping people housed. So HUD has instituted an eviction moratorium for borrowers with HUD-supported or FHA-insured mortgages. Next, HUD is trying to connect people with potential relief that's available. So HUD is working with the Department of Treasury to help emergency rental assistance program grantees connect tenants behind on their rent or utilities with financial assistance. And lastly, HUD is providing tools to help public housing authorities, HUD-assisted landlords and tenants, and people experiencing homelessness. So our HUD program offices have delivered webinars, created documents, answered frequently asked questions, granted waivers to ease administrative burdens created by the pandemic, and are distributing relief resources such as American housing vouchers and additional assistance to people experiencing homelessness as quickly as possible. In this slide, I have the links to some resources that are available. So the first link is to information regarding rental housing counseling and eviction prevention information. The second link is for tools for landlords and tenants who are impacted by COVID-19. The next link is to tenant guidance on rental repayment plans. And then there's a link to homeless systems response dealing with the strategies for eviction prevention. And then the last link is to the National Fair Housing Training Academy Forum, which they held with the topic being the looming eviction crisis due to the COVID-19 pandemic. So I had spoken previously regarding the financial resources that were made available to FAP agencies under the partnership funds. So now I want to talk a little bit about some of the resources that were made available under the Special Enforcement Efforts, or SEC funds. So in June of 2021, HUD also made available to FAP agencies $100,000 in Special Enforcement Efforts funds to support extraordinary enforcement activities. So these funds can be requested by FAP agencies to support their extraordinary activities that they are undertaking in order to seek prompt judicial action to stay evictions in jurisdictional fair housing matters filed under the FAP agency's cooperative agreement with HUD. So under the Fair Housing Act, it allows for HUD to petition the court to get prompt judicial action so that HUD can petition for injunctive relief against a respondent to maintain a status quo while the fair housing investigation is conducted. And state and local FAP agencies have similar provisions in their law. So this provision would allow either HUD or a FAP agency to petition the court for prompt judicial action to obtain a stay of an eviction pending the outcome of a fair housing complaint. And so all the state and local agencies have a provision that allow them to do that as well. And so HUD recognizes that with the eviction crisis and the moratorium is ending, there's the potential for a wave of discrimination cases that may come into the system that may require prompt judicial action. So there may be extraordinary expenses that are going to be imposed upon FAP agencies in order to deal with that. And so these SEE funds are available to specifically help offset some of those costs. So to be eligible to receive these funds, there are three requirements. First, the lifting of the moratorium must have led to the extraordinary expenses associated with the injunctive actions. So there must be a connection between the moratorium being lifted and the prompt judicial actions that are resulting in the extraordinary costs. Two, the expenditures must be related to a jurisdictional complaint filed under its cooperative agreement with HUD. So it must be related to a case that's been dual filed with HUD, a Title 8 case. And lastly, the agency was unable to secure directly from the respondent a voluntary stay of eviction regarding the matter pending the outcome of the investigation prior to seeking the prompt judicial action. So generally, seeking an injunction or prompt judicial action should be a last resort because it's an extraordinary remedy. And so state or local agencies must exhaust all other means before resorting to it as a last resort. So they must be able to show that they've tried to get the respondent to voluntarily hold off on the eviction prior to seeking the presumption of judicial action. So if an agency can satisfy these three requirements, they can request from HUD funds under these SEE funds. So that brings me to the end of my presentation. So at this time, I want to conclude on this last slide and say that persons who believe that they've experienced discrimination may file a complaint by contacting HUD's office at the information that I have depicted on the slide, or by visiting our website. I do want to emphasize that during the pandemic, our staff are working remotely, so they're not in the office. So the best way to contact us is through email or through our website. However, I want to emphasize to everyone that HUD is open for business. Our staff is continuing to work. We're continuing to intake complaints of discrimination. We're continuing to investigate those complaints, and we're continuing to litigate the cases where we've issued a charge of discrimination on. So HUD is here. So if you feel that you've been subject or know someone who's been subject to discrimination, please contact us, or you can contact one of our staff partners as well. So with that, I will turn it back over to Tammy. I believe we have some time for questions, so we can go ahead and proceed there.
All right. Well, first of all, thank you again, Mr. Meltesen, for your time and your very informative presentation and all of the resources that you have shared with us today, all of the resources and great information that you've shared with us today. There are a few questions that people want answers to. And one of the first ones was, will you have these slides available so that we can share with all of the participants that were a part of this conference, and then obviously they can share with some of those who wanted to be here and couldn't be here today. Is that part of the plan?
Yeah, and my slide presentation can definitely be made available to everyone who's participating.
Okay. And so thank you for that. And then the next question that we have, it was during the time when you were giving the statistics about the number of cases and the type of cases that the FAP agencies have been dealing with. Someone said that they did not see any complaints from Michigan City, and they were wondering, if there were any complaints coming out of Michigan City.
Okay, so that is a very good question. Thank you for asking that. So the agencies that was reflected on the slides were agencies that have a cooperating agreement with HUD. There are other cities and municipalities that enforce fair housing organizations and so Michigan City may be a local government that has an organization that is accepting complaints, but because we don't have a work sharing agreement with them, those cases are investigated entirely by them, so we wouldn't have that information available. Also, it's possible that contained within those statistics are cases involving discrimination that's occurring within Michigan City, because I didn't break it down for specific locations. So those complaints might have been handled by HUD, or they might have been handled by the Indiana Civil Rights Commission as well. Unfortunately, I don't have the specific breakdowns of all the cases to see if Michigan City was one of them. If you're interested in those statistics, you can always contact our office and submit a Freedom of Information request, ask the number of complaints that we filed, and that's information that we can respond to.
Okay, thank you for that. And the other question that we have, and let me back up for a moment, and whomever asked that question, hopefully that answers the question that you have. And like Mr. Milton said, that you can always reach out to them and ask for a information request form, or put in an information request form. And so that hopefully that answers your question. If not, then please write me again in the chat box. The other question says, some landlords do care when they rent to, let's see, some landlords do care who they rent to when checking the sex offender map. They are within 1,000 feet of a school, park, or daycare. Is there any action or complaint process for this type of issue? So it sounds like when there's housing available near schools, basically it sounds like, does the landlord kind of have a right to refuse to someone who may be on the sex offender list because they are within 1,000 feet of a school or a park or a daycare? And so I guess that's what the question is alluding to. And if I'm wrong, someone can please correct me on that.
Okay, so I guess the best way I could answer that is under the Fair Housing Act, it prohibits discrimination based upon 7 specific categories based on race, color, religion, disability, national origin, familial status, and sex. So those are going to be the categories where a landlord cannot base a decision on. So if the restriction is based on a factor outside of a protected basis, then it's not going to be covered by the Fair Housing Act unless there is a disparate impact on a protected category that is protected. So if it falls outside of one of those 7 protected bases, then it's not going to be something that's going to fall under the Fair Housing Act. Now, there may be state or local laws that address that specific issue, but those would have to be enforced by the government agencies that enforce those laws.
And thank you for that. We do have another question here. The next question is, should FAPS expect training regarding over 6,000 Afghan refugees that are now at Camp Atterbury and may be integrated in communities in Indiana? And the second part of the question is, will the refugees be covered by the Fair Housing Act? And if you want me to, I can repeat the first question for you. Again, that first question is, should FAPS expect training regarding over 6,000 Afghan refugees that are now at Camp Atterbury and may be integrated in communities in Indiana?
Okay, so let me answer the second part first, and I'm going to kind of go back to my previous answer that whether the refugees are protected or not. So again, the Fair Housing Act protects against discrimination based on one of those 7 categories. So if the person who's a refugee is being denied housing based on their race, based on their sex or their familiar status, then that's something that would be jurisdictional under the Fair Housing Act, and could be a potential complaint. In terms of training specific to that issue, I'm not aware of specific training. If there's a need, if a FAP agency feels that there's a specific need for training along those lines, then I would suggest that they reach out to us here at HUD or the National Fair Housing Training Academy and check to see what kind of curriculum they may have for training. They might have some training that may be appropriate, or I know they're always interested in developing new curriculum, so that could be a potential source of curriculum as well. But I'm not, off the top of my head, I'm not aware of any specific training that's available regarding that right now.
Okay, thank you for that information. And I believe that was from Miss Diane out of Evansville. Hopefully that's answered your question. If not, let me know, and we can ask for more clarification. And let's see, and the other question that I have, and I think this is the last one that I see thus far, is with regards to, I believe it was the $20 million of money set aside for legal assistance. How would an agency get more information about that, or how would they access information about the legal assistance that's being provided, or the dollars for the legal assistance being provided?
Yeah, I would, since those funds aren't being administered by my office, the Office of Fair Housing and Equal Opportunity, I would refer you to HUD's website, and there's more information on our website, which should be able to help you with that. But since we don't administer it, I'm not as familiar with all the requirements of that. So I would kind of refer to check out our website, and you should be able to find information there regarding that program.
Okay. And let me double check. I'm checking both the chat box and the Q&A section to make sure I've not missed anybody or anything. And it looks like I have not missed anybody or anything at this point in time. So again, Mr. Meltesen, we the consortium and all of the participants greatly appreciate you and your time. Thank you for joining us. And it's unfortunate that we weren't able to have our annual conference this year because of COVID and its everlasting effects. However, as you know, we are planning our June 2022 conference, and at that time, we'll be reaching back out to you in hopes that you will be a part of our annual conference next year. And we're hoping for that we can all do this in person. So please put us back on your calendar and please consider joining us again in 2022.
Thank you very much, Tammy. And I really appreciate the invite to me to be here today. So I really enjoyed the opportunity to share with all of your members what HUD is doing to address these difficult issues. So thank you very much. I appreciate it.
All right, and I know that you've got a very busy schedule, so by all means, we again appreciate your time, and I know you have to go ahead and leave us at this point, so please enjoy the rest of your day, and we'll be talking to you soon about, like I said, coming back in 2022 with us, okay?
All right, sounds good. Take care.
All right, thank you. And so to all of our participants at this time, I thank you all very much for being here. Actually, we got finished with this session just a little bit early, which is great because that gives all of you an opportunity to take a break. So if you need to stretch, get some water, get some snacks, by all means, please go ahead and do that. Coming up next, immediately after your break here, we will have session 2, and session 2 is ADA and COVID-19, what you need to know. Our presenters for our second session will be by Marcy Hensman and Peter Berg. So if you all would like to take, let's say it's, what time is it? It is 12:46. So if you guys, and this is Eastern time, so if you guys want to be back here about 12:55, we will start to, I'll do some introductions, and that way Marcy and Peter can take over at 1 o'clock with their presentation. So thank you for staying with us. Thank you for joining us, and we'll see you guys back here about 12:55 Eastern time, and what is it, 11:55 Chicago time. That's what my friend Tatanisha from Michigan City told me how to address Central time, call it Chicago time. So see you guys back here in just a few minutes. Thank you. And thank all of you for your all of your questions, and you're welcome, Ms. Diane.
audio settings button left mute. Currently muted.
Okay. We are back and we will get started here in just a few moments. Hi, Peter. I see you.
Tammy, how are you? Are you able to hear me all right?
Yes, I can.
Excellent.
Hi, Marcy. How are you?
Good afternoon.
Good deal. So it worked out well. We got a natural break in here, right? All is good. And I'll give it just a few minutes before we get started. Some people are coming in, I know, specifically for the second session, so we'll give them here a few moments just to get started. So what I'll do is I'll go ahead and get the intros out the way, and so by that time we'll probably be starting right at 1 o'clock with your presentation. So those coming in, they won't miss any of the presentation. The only thing that they'll miss is me reading a little bit of about your bios. So welcome back, everyone. We're here for session 2, and again, session 2 is with the ADA. The topic, title is ADA and COVID-19: What You Need to Know. Our presenters are Marcy Hensman and Peter Berg. During this session, they will discuss ADA implementations around mask and vaccination requirements with state and local governments and private organizations. Additionally, they will review the implications identified by various types and forms of disability around COVID-19. During this session, Marcy will actually field the questions and they will respond accordingly during the presentation. So what that means is that I get a little break here. So thank you, Marcy. I will also give a warning, a 5-minute warning when this session is near its end, just so that everyone is aware of that. And so with that being said, Marcy Hensman, she is a research specialist with Great Lakes ADA Center. Marcy is a certified rehabilitation counselor who has worked in state and federal government rehabilitation services. She obtained her bachelor's degree in psychology from Purdue University and graduated with her master's degree in rehabilitation counseling from the State University of New York at Buffalo. Marcy served as the chair of ADA Indiana Steering Committee for 7 years during her 13-year participation. Throughout her 7-year tenure as the Assistant Director of Affirmative Action and ADA Programs, Marcy was tasked with ensuring that Purdue University was in compliance with all titles of the ADA, as well as other disability laws. While at Purdue, she evaluated faculty and staff for reasonable accommodations, addressed access barriers, implemented and oversaw the university's web accessibility policy, served on numerous committees, as well as developed and delivered ADA-related trainings. And Peter has an impressive bio as well. And so Peter Berg, he is the project coordinator of technical assistance at Great Lakes ADA. And Peter has been coordinating and providing technical assistance as well as conducting training on various aspects of the ADA since he joined the Great Lakes Center in October of 2000. He is a graduate of North Central College in Naperville, Illinois, with a bachelor's degree in history. And prior to joining the center, he spent 7 years with Dominic's Finer Foods, the last 2 years as a customer service manager. Peter recently served as a member of the Illinois Attorney General's Office, Illinois' Accessibility Code Task Force, and is the former chair of the Mayor's Advisory Commission on Disability for the city of Naperville, where he resides. Peter was a 2010 recipient of the Chancellor's Award of Merit and former chair of the Chancellor's Committee on the Status of Persons with Disability at the University of Illinois. In June of 2017, he completed the ADA Coordinator Training Certification Program through the University of Missouri, College of Human and Environmental Sciences, and School of Architectural Studies. And so today, again, I want to thank both Marcy Hinsman and Peter for taking the time to join us today. And with that being said, I think we are right at 1 o'clock. So Marcy, you are first up, and once she's done, she will tag Peter to take over. So Marcy, welcome and thank you.
Thank you, Tammy, for that introduction, and good afternoon, everyone. I'm going to get us started by reviewing the ADA framework that applies to masking and vaccinations. We will provide Tammy this PowerPoint handout after today's session so she can email it to all of you. Just a reminder, if you have a question, please just type it in the Q&A box so we can address it at the end of our presentation, and we can voice those questions so everyone can hear them and reply to them. We will save time at the end for everyone's questions. Thank you. So to give perspective on this important topic, let's just start off with some statistics. According to the CDC, 1 in 4 adults are living with a disability in the US. That's approximately 61 million Americans that have at least one disability, making people with disabilities the largest minority group in the nation, an estimated 26% of the total population and growing. 40% of those with disabilities are over the age of 65. And the US Census Bureau projects that in 2030, all baby boomers will be at least 65. This projection suggests that the number of people with disabilities will more than likely increase in the next decade. And did you know that 80% of disabilities are hidden? Many disabilities are not always obvious for many reasons. For example, an individual may have learned how to successfully manage their disorder and minimize symptoms. Other times, it may not be apparent in certain situations, like a learning disability, which can be more obvious in an academic setting and less obvious in a social context. Living with a hidden disability can make daily life more demanding for many people, but it can be difficult for others to identify, acknowledge, or understand the challenges a person with a hidden disability faces. It's important to keep in mind that no two people are affected by the same disability in the same way. Title II of the ADA prohibits discrimination against qualified individuals with disabilities in all programs, activities, and services of public entities. It applies to all state and local governments, their departments and agencies, and any other instrumentalities or special purpose districts of state or local governments. It clarifies the requirements of Section 504 of the Rehab Act as amended for public transportation systems that receive federal finance assistance and extends coverage to all public entities that provide public transportation, whether or not they receive federal financial assistance. And it establishes detailed standards for the operation of public transit systems, including commuter and intercity rail, such as Amtrak. Title III of the ADA prohibits discrimination on the basis of disability and the full and equal enjoyment of goods, services, facilities, privileges, advantages, and accommodations of any place of public accommodation, such as restaurants, department stores, salons, fitness centers, movie theaters, doctors' offices, and so on. To be protected under the ADA, an individual must meet the definition of disability. This statement leads to the question of who falls into the category of a person with a disability. Well, notice that there are 3 parts to the definition. 1, a person has an actual disability. 2, a person has a record of a qualifying disability. Or 3, is regarded as a person with a disability having a disability, whether or not they do. For the purpose of today's session, let's break down the first prong of the definition by focusing on some key terms. A physical impairment is any physiological disorder, condition, cosmetic disfigurement, or anatomical loss affecting one or more body systems. A mental impairment is any mental or psychological disorder, such as intellectual disabilities, organic brain syndrome, emotional or mental illness, and specific learning disabilities. Generally speaking, major life activities are ones that are important to us in our daily lives, such as caring for oneself, walking, speaking, breathing, hearing, sitting, interacting with others, thinking, concentrating, and so on. Major bodily functions are also major life activities and include functions such as neurological, cardiovascular, normal cell growth, digestive, bowel, functions of the immune system, and so on. The impairment's impact on the major life activity is evaluated without regards to mitigating measures such as medical treatment, medications, or assistive devices. The individualized assessment of some types of impairments will, in virtually all cases, result in finding the impairment substantially limits a major life activity, and thus the necessary individualized assessment of these types of impairments. They should particularly be simple and straightforward. For example, blindness and deafness. Other times, similar diagnosis impairments such as allergies or asthma may not meet the definition of disability, depending on medical documentation regarding the substantial limitations, which is why there is an individualized assessment. Although many people with COVID-19 get better within weeks, some people continue to experience symptoms that can last months after first being affected, or may have new or recurring symptoms at a later date. This can happen to anyone who's had COVID-19, even if the initial illness was mild. People with this condition are sometimes called long haulers. This condition is known as long COVID. Considering the rise of long COVID as a persistent and significant health issue, the Office of Civil Rights of the Department of Health and Human Services and the Civil Rights Division of the Department of Justice have joined together to provide guidance, which explains that long COVID can be a disability under Title II, State and Local Government, and Title III, Public Accommodations of the ADA, which I'm going to review. So according to the CDC, people with long COVID have a range of new or ongoing symptoms that can last weeks or months after they are infected with the virus that causes COVID-19. And that can worsen with physical and mental activity. On this slide, on the left-hand column, you will find examples of common symptoms of long COVID. This is not an exhaustive list. Some people also experience damage to multiple organs, including the heart, lungs, kidneys, skin, and brain. Long COVID as a physiological condition affects one or more body systems, such as lung damage, heart damage, including inflammation of the heart muscle, kidney damage, neurological damage, damage to circulatory systems, resulting in poor blood flow, lingering emotional illness, and other mental health conditions. Accordingly, long COVID is a physical or mental impairment under the ADA. Long COVID can substantially limit a major life activity. The situations in which an individual with long COVID might be substantially limited in a major life activity are diverse. Among possible examples, some include a person with long COVID who has lung damage that causes shortness of breath, fatigue, and related effects is substantially limited in respiratory function, among other major life activities. A person with long COVID who has symptoms of intestinal pain, vomiting, and nausea that have lingered for months is substantially limited in gastrointestinal function, among other major life activities. Or a person with long COVID who experiences memory lapses and brain fog is substantially limited in brain function, concentrating, and/or thinking. So COVID is not always a disability. An individualized assessment is necessary to determine whether a person's long COVID condition or any of its symptoms substantially limit a major life activity. Studies have shown that some people with certain disabilities are more likely to get COVID-19 and have worse outcomes. The severe COVID outcomes individuals are experiencing are hospitalization, admission to the intensive care unit, intubation or medical ventilation, and or death. It's important to keep in mind that people with disabilities are more likely than those without disabilities to have chronic health conditions, live in congregated settings, and face more barriers to healthcare. Our recent CDC study found that 95% of hospitalized COVID patients had at least one pre-existing condition. Studies also show that certain common medical conditions put people at higher risk for severe illness from COVID-19. These include hyperlipidemia, metabolic disorders like diabetes and obesity, as well as heart conditions like high blood pressure or hypertension and chronic pulmonary disease. More data about COVID-19 and its impact on people with Down syndrome are needed, but limited published findings so far suggest that individuals with Down syndrome over the age of 40 are more likely to need hospitalization, have serious illness, or die from COVID-19 compared to the general population of the same age. Keep in mind that people with Down syndrome often have underlying medical conditions that make individuals at an increased risk or possibly at increased risk for severe illness from COVID-19, according to CDC. This includes cancer, overweight and obesity, heart conditions, immunocompromised state or weakened immune system from bone transplant, immune deficiencies, or of the use of other immune weakening medications, type 1 and type 2 diabetes, and neurological conditions such as dementia. Under the ADA, safety requirements must be based on actual risk and not on mere speculation, stereotypes, or generalizations about individuals with disabilities. For example, a wilderness tour company may require participants to meet a necessary level of swimming proficiency in order to participate in a rafting expedition. In regards to eligibility criteria, governments and businesses may not impose eligibility criteria that either screen out or tend to screen out persons with disabilities, unless it can show that the requirements are necessary for the provisions of goods, services, privileges, advantages, or accommodations. In terms of safety, governments and businesses may impose legitimate safety requirements necessary for safe operation. However, governments and businesses must ensure that its safety requirements are based on real risk. Again, not on speculation, stereotypes, or generalizations about individuals with disabilities. Governments and businesses may not impose a surcharge to cover the cost of measures required to provide non-discriminating treatment required by the Act or this part. Asking for disability-related information pertaining to a requested modification is generally prohibited in the context of routine government and business transactions and programs and services. The reason being is that non-disabled individuals are not required to meet such prerequisites before they access programs and services. This is the spirit of the ADA, and it's to foster equal access and inclusion and economic activities for people with disabilities. Requiring proof of a disability would amount to discrimination or exclusion from having equal access to routine goods and services. Ask yourself, is my safety requirement truly a safety requirement? If it is, then this issue doesn't matter because you're not going to modify your safety requirement. Disability-related inquiries are permissible depending on the nature of the relationship between an individual with a disability and a public accommodation. For example, public and private colleges may ask registered students with non-obvious disabilities for limited and relevant information from an appropriate licensed professional to justify semester-long classroom or testing modifications. A daycare center may ask for limited or relevant medical information when a child requires specialized attention due to a disability, such as insulin shots, administering medications, or special dietary needs due to allergies or diabetes. Governments and businesses shall make reasonable modifications in policies, practices, or procedures when the modifications are necessary to afford goods, services, facilities, privileges, advantages, or accommodations to individuals with disabilities, unless it can demonstrate that making the modifications would fundamentally alter the nature of the goods, services, facilities, privileges, advantages, or accommodations. Full and equal enjoyment means the right to participate and to have an equal opportunity to obtain the same results as others to the greatest extent possible. It does not mean that an individual with disability must achieve an identical result or level of achievement as persons without a disability. Now that we have that framework, I'm going to turn it over to Peter to get more in depth with face coverings. Peter.
All right, thank you very much, Marcy. And we are on slide number 14 right now. And what we're going to be talking about over the next few slides, talking about face coverings, safety requirements that Marcy was just mentioning, reasonable modifications, implications for certain types of disabilities, and communication issues, barriers that may arise. I want to emphasize right here, as Marcy did a great job providing you with an overview and the basic applications of the ADA. Nothing in the ADA has changed as we are all here participating in this webinar. Nothing in the ADA has changed since a pandemic was declared in 2020. What has changed is the environment in which we currently exist and the application of the ADA to the current environment. But the language, the requirement, the regulatory requirements of the ADA have not changed. So just to understand that, and as we go on to our next slide, I can tell you there's been a lot of confusion around the issue of face mask requirements and face covering requirements. When we were in the midst of last summer's surge in a COVID transmission, I think all 6 of the states that our center covers, governors issued executive orders mandating face coverings, face mask in indoor settings. And the language that Marcy was just talking about, the safety requirements, that language has always been part of the ADA. That was nothing new. That was nothing new that was added, when COVID became or was declared to be a pandemic. That language has always been there. It remains the same. And so at this point in time, we're still where the Centers for Disease Control, CDC, as well as most state and local health departments are declaring the coronavirus, COVID-19, to be a pandemic. And where a state or local government or where a business is relying on, Marcy talked about, relying on actual factual medical information, well, where one is relying on the Centers for Disease Control, the state, local health department, or even one's own health experts. The larger companies may have their own health experts, where the requirement to wear a face mask is based on that guidance that says, you in order to protect your staff, your clients, your participants, your customers, face coverings, need to be worn in indoor settings where, for whatever the reason, where you can't maintain social distancing, where there's poor ventilation, where there's just too much high volume. That's a legitimate safety requirement. And where we've seen, and where Marcy and I have gotten lots of phone calls and emails and contacts sent through our website, are oftentimes from individuals with disabilities who are unable to wear a face covering because of a disability, and feel as though that their rights under the Americans with Disabilities Act are being violated when they are denied access into a building or facility that's operated by a state or local government or by a private business. And it is, in fact, it isn't a violation of the ADA. And we've had some tough conversations with folks, and people understandably are upset when they're told that, because of their disability, because they're unable to wear a face covering because of their disability, they can't participate. They can't go in and purchase, groceries at their local grocery store because they can't wear a face covering. But again, to reiterate, where they are based on these legitimate safety requirements, they face covering, face mask policy can be implemented and it can be enforced. Now, let's, a year from now, let's hope we're no longer in a pandemic, and we're all, all has moved on and we're in a better place. A business could still have a face mask, requirement, saying everyone that enters into our business has to wear a face mask. But at that point, if there isn't a pandemic going on, they can't say it's a legitimate safety requirement. At that point, a business or a state or local government may have to modify that requirement because it's no longer based on a legitimate safety requirement. So just to be clear, and either it's a legitimate safety requirement, and Marcy, talked about documentation, and generally, as she pointed out, the ADA doesn't allow to ask for medical documentation. It shouldn't even be a question of whether or not medical documentation may be requested, and confusion was generated around the documentation in large part because many of the states, when governors issued their executive orders requiring face coverings, there were exceptions put into those executive orders that talked about people with disabilities who may not be able to wear it because of a disability, or where there would be communication barriers for someone wearing a face covering. Those were specific to to the governors, to that particular state's executive order. But in general, even if you were permitted to ask for documentation under the ADA, there would be no reason to ask someone for documentation. If someone said they can't wear a face covering because of a disability, there's no need to ask for any documentation. Either it's a legitimate safety requirement and everyone has to wear a face covering because it is for the health and safety of everyone inside of that building or facility, where there's a potential direct threat for anyone not wearing a face covering, whether that's a person with or without a disability. There isn't even a need or discussion of documentation. Either it's a legitimate safety requirement, or it's not a legitimate necessary safety requirement for the safe delivery of goods and services. All right, on to slide 16. We've had lots of calls on the other side as well, Marcy and I and other staff here at the center, and emails from businesses and state and local governments. And oftentimes they were confused by executive orders of their governors, and where they wanted to implement they were afraid. Lots of calls from businesses in one state where they thought they were going to be fined because they wanted to allow someone that was stating they couldn't wear a face covering because of a disability into their business. They wanted the business owner wanted to provide access to goods and services, but they were afraid that they were going to get fined, that the state or local health departments were going to come in and place a fine on them if they let someone in without a face covering. So it's difficult. And I'm sure you've all seen or heard, lots of recordings on social media and disseminated through the news, where people have, gone a little overboard when told by a business and a staff person that they can't come in, without a face covering. So it is difficult. It's difficult for, can be difficult for businesses, can be, difficult for state and local governments, but training, as with anything, and especially when it comes to the ADA, training staff and being consistent in the implementation of the policy. If you have the policy, consistency with, with the policy. So if someone tries to enter a building or facility where you have a policy that says you have to wear a face mask, ask the person, hey, we have a policy, everyone entering the building has to wear a face mask. Sorry, but that's the rule, that's the policy that we have. Sometimes people forget. Now, during the summer, we didn't, most states relaxed, face covering requirements. And now as we moved into the fall, some states have moved back to them. In the state of Illinois, where I'm located, a few weeks ago, the state of Illinois went back to a requirement, regardless of vaccination status, everyone in indoor settings has to, wear face covering. So as we moved into the fall, some folks, just aren't gotten out of the habit of putting a face mask. So, reminding someone as they come in, hey, we have a face mask, policy. If someone, doesn't have one, it's, good practice, not required by the ADA, but to say, hey, we've got, these disposable, face coverings, you can wear this. While you're in our facility. you know, if they state that no, they're not going to wear it, and they just simply say they're not going to wear it, then, you know, that's the end of it. It's not an ADA issue. You know, if someone indicates that they, you know, are unable to wear a face covering due to a disability, then we look at reasonable modifications. And when we're talking about here, we're not talking about a modification to the safety requirement, because we've determined, you know, the business, the state or local government has made that determination that it's a legitimate safety requirement. So now the modification is, okay, how can we still provide someone with a disability an opportunity to access the goods and services, the programs that are being offered by the state or local government or by the business entity? Now, it may not be the specific opportunity or the manner in which the individual with the disability wishes to access goods and services, but again, at this point in time during the pandemic, where there's a high transmission, they may need to, they being the person with the disability, recognize and accept that they are going to access goods and services in a manner differently if they're unable to wear, you know, a face mask. And it can also be, you know, particular to the, you know, to the situation. Just, you know, an example, you know, when someone says they can't wear a face covering, you know, let's take the example of at a healthcare clinic or a public health department where someone needs to come in and get an appointment, they need to be seen. Well, is it the individual, you know, can't wear a face covering, period, or can they only wear it for a short period of time? So is the modification, you know, instead of making that person wait in the waiting room and check in, instead that individual is allowed to check in by phone and they wait in their vehicle until it's their time to be seen. Then they're able to wear the mask for a short period of time, get through the lobby, they're, you know, taken back to their own room, and then they wait in there until it's their turn to be seen, and so forth. So, you know, having discussions, not getting, you know, any type of discussion into the nature of the person's disability, but really looking at, you know, the bottom line. How can we, you know, as a organization, as a public entity, as a business, still provide access to our goods, services, and activities in a way that isn't typical? So thinking outside of the box, and there are going to be ways to do that. And as we move on to slide 17, you know, I've heard from several people with disabilities who have been very open to some of the changes that have occurred. An individual who's a member of the Paralyzed Veterans of America that I did a presentation with earlier this year talked about how much he really likes and appreciates access to telehealth. And as someone that uses a wheelchair and drives his, you know, lift-equipped van, that the time that it saves him to drive a couple of hours to get to his medical appointments and then find parking and then get in, that telehealth has really opened up the opportunity for, you know, for medical visits. And hopefully this is something that we, you know, that we see going forward as a continued option. And increasing access to, we're going to talk a little bit later on, you know, but providing access to those marginalized, you know, communities who have been underserved by the healthcare industry and healthcare field in general, and that includes people with disabilities, people of, you know, people of color. You know, there are times where an individual with a disability or someone with a medical condition can't get their prescription refilled until, you know, their doctor, their healthcare provider says you have to come in and see us first. Well, you know, that individual may be reliant on someone else for transportation or reliant on public transportation, and now the person that was going to give them a ride, you know, is no longer available, or public transportation is poor in the area where they reside, and now this individual doesn't get their prescriptions filled, and now they're having increased, you know, medical issues because they couldn't. And going forward, you know, remote healthcare, remote telehealth, you know, allowing access, a phone call for someone with a, you know, to check in with their healthcare provider and get questions answered by their, you know, the doctor. Hey, how are you doing? What are you doing? You know, and being able to keep someone on their you know, on their regimen is critical. So hopefully, you know, some of these things are beneficial. Hopefully hopefully they will continue to be offered. But in the context of modifications, we've seen a lot of businesses, restaurants go to curbside pickup. So now someone can't come into the building facility because they can't wear a face covering. Now that individual is allowed to phone in their order. They're allowed to email their order. They're allowed to go online and place that order and schedule a time to drive up and have curbside pickup for that item. Or a business is providing curbside or providing delivery, free delivery, where they typically didn't do so in the past. And we've seen lots of restaurants get into the business of providing delivery or connecting with other third-party delivery companies. So looking and being flexible, and this is critical for whether you're a public entity or you're a business, that the folks that are answering phones, responding to emails, responding to contact forms submitted on your websites, it's critical that the initial response is never no. We don't do that. We've never done that. We've never done that in the past, because the individual that's making the request, if it's disability related, maybe you can't do it the way in which the individual wants, but there may be another way. So having that dialogue, discussing what the individual's actual needs are, what their limitations are in terms of wearing a face covering and accessing goods and services, and coming up with a modification in that in the way that goods and services are typically delivered, and coming up with something that works for the business, the public entity, and most importantly for the person with a disability who's trying to access goods and services. A couple of other things they talk about, face shields. So clear face shields, is that a possibility in a particular environment? Or, there are different things in terms of recommendations from CDC and other entities, but that may be, an option in a certain environment where someone, may feel claustrophobic wearing a face mask tight across their face. So is a face shield a possibility where they could have a scarf or something loosely, tied around the bottom of the face shield? So there's still, the particles that are, responsible for the transmission of COVID are still being caught, and they're not being, sent into the air for other people to potentially, get, are there other ways to look at that? Some settings that may not be possible, but again, being open to different types of options. All right, slide 18, looking at, implications. This is more just for to make folks aware, because there's often a knee-jerk reaction, and we probably all have been guilty at this at one point or another. And think of the example of someone watching someone pull into an accessible parking space at the mall and see someone get out of their vehicle. They're not using a wheelchair, they're not using a cane, crutches, a walker, and they walk into the shopping mall, and someone's sitting in their parking space thinking, hey, that's a fraud, that's a scam. That person doesn't have any type of disability, and they've got a parking. They probably stole that parking placket from grandma, and they're using that. Just to realize that everyone that requires the use of an accessible parking space may not be someone with a visible disability. Marcy talked about, when she was talking about disability statistics, the majority of disability is not apparent. It's not obvious. So someone that qualifies for a parking placard, which is determined at a state level, state by state, that is that defines, who qualifies to use accessible parking spaces. But most states, in the definition, talk about something, difficulty walking X number of feet without assistance. So, there are lots of people, with respiratory or other types of conditions, cardio conditions, that prevent them from walking long distance. And so that's their need for the accessible parking space, because, they're too tired, too fatigued, to get into the building or facility. And that's why they need the closer space. So in terms of face covering requirements, We just want you to be aware so that there isn't, and when you work with your staff and others in the public, you don't want that knee-jerk reaction that, everyone that's making a request saying, I can't wear a face covering, because of a disability. That it isn't, oh, this person's lying. They don't look like they have a disability. Well, how do you know? You don't know, because the majority of disability is not visible. So just to be aware, and this was something that early on, for me, actually was very enlightening when getting calls early on when states began to implement face covering requirements. I was enlightened, a little surprised, because I didn't realize the extent of the various types of disabilities that could be impacted by face covering requirements. So, individuals with post-traumatic stress disorder, PTSD, lots of calls people, with anxiety. Not to say that everyone with anxiety is a person with a disability, but different individuals with autism, respiratory, asthma conditions. So there are lots of conditions where you would never know that a face covering could be problematic. So just to be aware, and again, it goes back to that training, and that that the no should never be the initial response, and stick with your policy and have that discussion, dialogue with the individual, and understand their needs and ways that that you may still be able to provide them with access to goods and services. In the end, there may be certain services where someone may not be able to obtain access to that service during requirements where there's where a face covering is required. Individuals, instances where social distancing or other things can't be maintained. Personal services such as hair care, nails, those types of things. It may not be possible in those settings to come up with another way to provide access to goods and services. And that at this time it's unfortunate, but there may be some individuals who, because of their disability, inability to wear a face mask, face covering, won't be able to access those goods and services at this time. But a majority of goods and services that are offered and still available during the pandemic can be made available in different ways for people unable to wear face coverings because of a disability. All right. Looking at our time here, on to slide 19, looking at communication issues, because these face coverings can cover, present an issue for individuals with communication disabilities. When we're talking about individuals who are deaf or hard of hearing, when we incorporate some disability awareness into the ADA trainings that we do, staff here at the center, we talk about when, communicating, with someone that is using a sign language interpreter or someone who may be hard of hearing, that it's important to look directly, speak directly to the individual. Don't be eating or drinking while you're talking to someone. Don't have your hands up by your face. Those impede the ability for the individual to understand, or the interpreter, or someone who is reliant on, they may be hard of hearing, have some hearing, but are reliant on also being able to read someone's lips. Well, if you're doing those types of things, putting food, drink near your mouth, your hands, you're blocking that. So now think of it in terms of, now you're putting a face covering over your entire face. There was a sort of cool thing that came out of Oregon, either earlier this year or late last year, where Nike had been sued in their Nike stores by individuals who are deaf or hard of hearing, and saying that they were deprived of effective communication required by the ADA because the staff in these stores were not with wearing their face coverings. The customers who were deaf or hard of hearing couldn't understand, what the staff, and when they were asking questions and asking for assistance, they couldn't understand it. So that was actually resolved, and Nike came up with a policy and provided, frontline staff with a clear face mask. to facilitate communication so individuals could still see their face, because so that someone could still read their lips. Facial expressions are, important, and interpreters do rely on that type of information when interpreting for someone. And also being open to other ways. So are there whiteboards? Are there notes that can be written back and forth? Is there a possibility for a brief conversation for a staff member, to lower their mask and keep a social distance where they can have a brief conversation to communicate with someone? But there are certainly ways to communicate, where possible, using text messaging, instant messaging, to communicate with individuals, using a computer terminal if that's available, so people can type notes back and forth for those brief exchanges. So just to realize that face coverings create a barrier also for someone with a disability who's deaf or hard of hearing, who can wear the face mask themselves, but are impacted by someone else wearing a face covering, where it impacts their ability to understand what's being communicated orally by a public entity or by a private business. All right, we are moving on to slide number 20, vaccinations. And folks, I should have, I'm remiss in not stating this earlier, but if you have questions as I go along, please submit them in the Q&A so that you don't forget them or jot them down, and then submit them in the Q&A area. Afterwards, we will get to all of your questions once I am through rambling on here. Okay, so we're on to slide 20 and the issue of vaccinations, which is well, face coverings have come back as an issue. Vaccination requirements are in the news and ever present. So we're going to talk about access to vaccines, vaccine requirements in order to participate, requiring proof of vaccination, another new thing that we've seen a little greater increase in that requirement. And then talking about the vaccine reluctancy, why someone may be apprehensive about getting, the vaccine. We unfortunately have heard, from federal public entities and portrayed in the media, that the current surge is a surge of the unvaccinated. There's a percentage of that unvaccinated population that have reasons and valid reasons for being reluctant to get vaccines. So and some individuals may be completely unable because of their medical condition or disability. So we'll talk a little bit about that as we go forward here. All right, talking about now we're on to slide 21. So now we're talking about access to the facilities where vaccinations are being provided. The overarching requirement of the ADA is to provide program access. That program access is the obligation for state and local governments. So when the ADA originally became effective and compliance with the ADA became required for state and local governments back in the early 90s, the law did not require state and local governments to go out and retrofit all of their existing buildings. The requirement was to look at all your programs, all your services, all your activities, and when you look at them as a whole, are they accessible to and usable by persons with disabilities in the aggregate? And then going forward, inaccessible buildings, as they were altered or changed use, access requirements may have changed. So when we talk about, state and local governments selecting physical sites for vaccinations, while the ADA may not say that you have to make 100% of them, it makes sense. Again, if we're wanting to, if the goal is to get as many people vaccinated as possible, a county entity, a public health department, a state health department, whomever is administering the vaccines, should be looking at locations that are accessible. Because guess what? If you select a location that is physically accessible parking, accessible routes, accessible entrance, accessible route to where the vaccines are being provided, guess what? No one is excluded. You're not excluding someone when a location is selected and it is physically inaccessible. there's a population within the community that can't access that site because they have a disability. So providing and selecting and choosing and identifying accessible locations is best to do because it's inclusive and it ensures that people have as many opportunities and choices and selection as anyone else to go and get vaccinated within their community if they choose to do so. If there are locations, if a community is looking to just ramp up and open up as many, vaccination sites as possible and just vaccinate large populations of individuals. And so maybe renting, inaccessible space, if that in fact happens, then it needs to be clearly indicated on whatever you're using. If you're using social media, if you're communicating with the public through email, listservs, your websites should contain information indicating if a site is inaccessible. If all your sites are not accessible, they should be identified as these are these are accessible locations for persons with mobility disabilities. You want to make that clear, make that information easy to find. Again, training staff, folks answering phone calls at call centers, that are offering information, appointments and locations of vaccination sites should have that information readily available so that individuals can easily find that information, and it doesn't require multiple phone calls and callbacks to get that information. On to slide 22. For Title III entities, so at Title III, we're talking about the private businesses. So your retail pharmacies, your Walgreens, your CVS's and Walmarts and all the other folks that are providing, providing vaccination sites either on their own or where they're working with the state or local government to make them available. The ongoing obligation under the ADA, no such thing as a grandfather clause, just slip that in there. It doesn't matter when the building was originally constructed. There's no grandfather clause in the ADA. Businesses that operate out of existing facilities, so buildings constructed prior to the effective date of the ADA 1991, have an ongoing obligation to identify and remove existing barriers from their facilities. Again, where a business is making vaccinations available and they have inaccessible locations, look at reasonable modifications, look at making clear where the accessible locations are available, so people don't have to work overtime just to identify where they can get access to a vaccine shot. On to the next slide, slide 23. The ADA and the ADA accessibility standards apply to temporary facilities. That again, nothing new here. This has always been a requirement. So temporary events have always been and continue to be subject to the ADA general non-discrimination requirements, as well as the 2010 standards for accessible design. So if a state or local government or private business is setting up a temporary vaccination site, it needs to be accessible. This is new. This isn't something that's existing. There's no way to argue, well, we just, this is temporary. No, a temporary vaccination site or a temporary testing site. I think we're starting to see testing ramp up again because of the current surge. So whether we're talking about a temporary vaccination site, a testing site, it needs to be accessible. So identifying accessible locations that have accessible parking, accessible routes. If you're using mobile, trailers and so forth, how is someone with a mobility disability going to get it into that trailer, into that mobile device to get their test or to get the vaccine? So in looking at thinking through those things beforehand and not having staff and others caught flat-footed when someone with a disability shows up and says, you're only providing vaccines in there and I can't get into that trailer. How are you going to accommodate me? How are you going to modify what you're doing to make sure that I can get access into there? On to slide 24, effective communication. always one of the general non-discrimination requirements of the ADA. Doesn't matter, what you're talking about in terms of programs, activities, or services, whether you're talking about vaccination programs, vaccination sites, effective communication is critical. So again, whether this is a permanent building or whether it's a temporary site, being ready, having staff, clear mask, the ability to use whiteboards, take notes, to answer questions, or being proactive and advertise and say, we're going to have a sign language interpreter here, reaching out to the deaf community. Not saying that that's a requirement, but it could be a very good way to reach out to that particular community, just as an example. But having staff prepared, again, no is never the initial response. No is never the first answer. So if someone comes in and indicates that they can't hear you, they can't hear the staff person, having staff trained to say, what, I need to, I know I should be writing notes back and forth to find out, how to best communicate with this individual, or how to best provide them with the information, regarding the potential side effects, or that once they get their vaccine, I need them to wait around 15 minutes because they indicated in their pre-health screening that they have had issues in the past when they've received vaccines. So we need this person to wait around 15 to 20 minutes. And I need to communicate that to the individual so they don't take off and then go out into the parking lot and potentially, faint. We want to monitor them. We're going to monitor their vital signs, over those 15 to 20 minutes. So being prepared, and hopefully a lot of this is already set in place, especially for public folks, for state and local government entities, because these requirements, again, are not new. Communication, it is always and continues to be, a core requirement, a general non-discrimination requirement under the ADA. Slide number 25. We saw earlier this year, we had done a webinar back in February, when vaccines were just starting to be rolled out. Vaccination started back in December and January, but those were typically for healthcare folks. And it was really February, March where we saw the rollout for the general public. And there were stories out there about individuals who use assistive technology. So individuals who are blind, low vision, and other types of print disabilities that were having difficulty being able to make appointments to schedule vaccinations, because individuals were required in certain counties, certain areas, that you had to go make your appointment online, and these websites were not accessible to persons using assistive technology, using screen readers. So it's critical. Again, this has always been a requirement under the effective communication requirements for state and local governments and businesses to ensure, communication with persons who are deaf, hard of hearing, blind, low vision is, that someone that's blind, low vision, deaf, hard of hearing has the same level of access to that information. So if you're relying on a website to provide information about COVID resources, where to find vaccination locations, or that's where you're required to make an appointment, those websites, those apps that you're using need to be accessible. Otherwise, you're requiring someone with a disability, because of a disability, to have to go through additional steps and take additional time to get access to a vaccine, whereas someone without a disability can go right to your website, select an appointment, and get a confirmation email. So those things should already be in place. If not, it needs to be a consideration as websites are built, as new pages are added, or if you're looking at a public entity looking at adding a third-party product, say that the website doesn't have the capability to make appointments, so you're looking at purchasing something from a vendor that allows you someone to reserve time to get a vaccination. That should be part of the discussion that you're having with that vendor. Is your product accessible? And if they say yes, that's great, and then make them demonstrate and prove to you that it's accessible, and not just take their word for it. So that can certainly be a barrier. Not just in the ability to make appointments, but also, oftentimes it's difficult. A lot of places don't talk on the phone anymore. They don't have people. You get sent to a phone tree or bounced around, and oftentimes people are pushed to a public entity's website, or they're pushed to social media, to an app. That's fine. That's great. As long as those are accessible, and as long as you're looking at other ways of disseminating information as well. Not everyone has access to smartphones or to the internet, for that matter. But where you're using that, where that's part of your strategy to disseminate information in general, and in particular when we're talking about information about the availability and the need to make vaccination appointments, those apps, those websites, those social media posts need to be accessible. So if you're posting videos about why people should get vaccinated and what the benefits are, and to try to dispel some of the myths or misinformation about there, and you're posting a video to your Facebook page, or you're tweeting it, or you're putting it up on YouTube, that should be captioned. That needs to be captioned so that someone that is deaf or hard of hearing has access, to that information. It's critical that you're providing access to that information in whatever form you're choosing or using to disseminate it. All right, slide 26. Reasonable modifications, putting information in plain language. Oftentimes information gets so complex for the average individual, but then think of individuals that may have cognitive or intellectual disabilities. So again, going back to the websites, using plain language so that people can understand it. And if someone's coming in for an appointment to get a vaccine, or to get information about COVID, or to get information about testing, information orally that's provided may need to be simplified, so that someone, because of a disability, may need that in order to be able to understand what you're communicating to them. A great example, and this is an example, providing seating. If someone if people have to come and wait in line, first come, first serve for vaccinations, you may need to provide seating. Even if you're not providing seating for everyone else, you may need to look at providing seating and allowing someone to check in and then go sit down. And then when it gets to their point in line, that they'll be called up for their vaccination. Again, the willingness, the ability to look at things, to consider things out of the box, and never saying no from the get-go. Service animals, always an ongoing issue, regardless of whether we're talking about COVID or any other event open to the public. Service animals are individually trained dogs that perform work or task for someone with a disability. You're permitted to ask 2 questions. Is that service animal needed because of a disability? If the individual says yes, the follow-up question can be, what work or task has the animal been trained to perform? Can't ask for any proof of certification, training of the dog. And you can't ask the individual to demonstrate the work or task that the animal has been trained to perform. All right, we're on to slide 27, and connecting with communities. And some of this I've touched on, but looking at your methods, your avenues for disseminating information within your particular community, and recognizing that there may be certain communities, certain populations that are getting vaccinated at a much lower rate than other communities. So looking at connecting with groups, with social service providers, with other organizations that are already serving those communities, and working to disseminate information through those larger organizations, those larger social service agencies, to get information to those particular populations who are not, getting vaccinated at the same rate. Social media is great. That's here at the at Great Lakes, Marcy and I and the center director and associate director, meet on a weekly basis to talk about the social media and information that we're disseminating, because that's a critical part and a critical way in which people receive information nowadays. So, connecting with the public, it's not the end all be all, because you have a population of individuals that may not not have access to the internet or smartphones and don't access social media. But there is a large, segment of the community that does use social media for information. So disseminating information that way, and more importantly, or most importantly, disseminating that information in a manner that is accessible. So providing captions for videos where you're using pictures, diagrams to disseminate and provide information that photo, that image provides a text description for someone that uses assistive technology. I went to great lengths with the city where I reside, because the police and fire departments would regularly post information on their Facebook and on Twitter. And some of it was just, a daily, announcement and so forth. But other times they were putting out, not that matters, they're putting out information, so it still needs to be accessible. My point is that at other times they were putting out critical information about a crime or something that occurred, or, a boil order because a water pipe was broken. And so oftentimes they would just post a picture of a news release, a press release. Well, that press release is not accessible to someone that's blind and who's using assistive technology. It just, when their screen reader goes over, it just says image or photo. So if you're going to use a photo or image to put information out there, whether it's on your website or through your social media, you need to make sure that there's alt text, that there's text descriptions of those videos, or I'm sorry, of those images. And if the folks that are putting up on the website or your IT folks don't know how to do that, then they should get trained and learn how to do so, immediately, because that's critical. All right. Slide 28, vaccination mandates. There's nothing in the ADA that prohibits governments or businesses from having vaccination mandates. In this instance, I can tell you that the United Center, where the Chicago Bulls and the Chicago Blackhawks play, announced a couple of weeks ago that they're going to require anyone attending a Bulls game or a Blackhawks game this season is going to have to show, proof of vaccine or a negative COVID test. I think they're requiring a negative COVID test within 24 hours. So where a business or a government entity has that vaccine requirement in order to enter the business or the government entity, is nothing in the ADA that would prohibit that. But this is an instance where, again, we've talked a lot about reasonable modifications, and modification may need to be made for someone who's unable to receive the vaccine because of a disability. So as I mentioned, the policy for the United Center, they built in that modification already. So that allowance for someone to enter, the building, if they're able to show a negative COVID test, covers anyone who just decides they don't want to get the vaccine, or someone who can't get it because of a disability, that they have an option. There's an alternative. There's a modification to the vaccine requirement that, okay, I can't get the vaccine because of a disability, because of the side effects it will pose. I can instead get a COVID test and prove that I'm negative, and I'll be able to gain admittance into the event or the building or the facility. All right, we're just a little past the top of the hour, and then just finish up here on why there may be some reluctancy within particular communities to getting the vaccine, and some of it goes back to just in general. You can say that people with disabilities overall have not had and continue to not have the greatest access to healthcare opportunities. For people with a variety of disabilities, mobility disabilities, for mental health, disabilities and other types of disabilities. So there's already a weariness, or of healthcare in general. And now, people are being told you need to get vaccinated. You need to trust us that this is safe. So you can understand where there may be some reluctancy within certain communities to go out and get vaccinated. People with HIV and other conditions that have pre-existing, their their autoimmune systems. They already have weakened autoimmune systems. So, getting the vaccine, potentially lowers that to an even lower threshold, and opens that individual to not just, to the potential to get other, things that typical someone can fight off a cold or the flu, in a typical amount of time, where for someone with a pre-existing condition, it can be, potentially life-threatening. And information for certain types of disabilities. While it seems in large part that the vaccines are safe, there are still certain groups where testing has not been done. We heard early on about whether or not women who were pregnant should be getting the vaccines, and there just wasn't enough testing research done on that prior to the rollout. So even with particular disability groups, there isn't a lot of research in terms of the impact of what may occur if they do receive the vaccine. And then there's also a population of people who, even if they get the vaccine and suffer, some significant side effects, that they may not even be fully, protected from exposure to the virus if they were to become exposed. So this is just to provide just an overview of why there may be some populations that have some reluctance to get vaccinated. Just as when we talked about disability, certain conditions that are impacted by wearing a face mask. It's really these two slides are really intended to to get people to take a pause and and take a step back and realize that appearances are not everything, and we never really know exactly what's going on with a particular individual when we encounter that individual, and we get a snapshot of that individual for 5 minutes, for 10 minutes, or even less. So just to realize, take pause, and have patience, and ultimately understand what the individual's needs are, and looking for an effective way that works for both the public entity, again, whether it's access to goods and services, or it's access to testing, or to COVID vaccines, that ultimately the goal is to provide the person access to whatever they're seeking, and looking at a way that can be done safely, that fits the needs of the individual, and is something that can be delivered by the government entity or the business. All right, and we are on to slide number 30, and time for questions. So this is your opportunity to ask questions of Marcy and myself, and anything that we've talked about at this point. And I think we have enough time, Marcy, that if folks even have some general questions related to employment and vaccine requirements and so forth, we could probably address those. But Marcy's going to talk about at the very end. We've got some upcoming webinars specifically on employment and COVID.
We've got 2 questions submitted in the Q&A. If you have any questions, please feel free to go ahead and type those in as we work on these other 2. Peter, the first one that was submitted was early on. It states Indiana state law requires a legal hearing to determine a person incapable of making their own medical decisions. Currently, Indiana does not have a mandatory mask requirement. How can you say this is not a discriminative action when people are refused access to public accommodations? I think that kind of goes back to what you were saying before, that it's important to keep the safety risks separate from providing access to goods and services.
Right.
As you stated, can be provided in a different manner. That's that modification, such as virtual options, pickup, delivery services. So you're upholding your safety risk policy, right? And yet you're brainstorming other ways to provide those goods and services.
Yeah, and I think the questioner is also making the point, or challenging the point that, well, if the state doesn't have a face covering mandate, how can a business have that policy? And they can, because again, if that business is relying, the CDC at this time, Centers for Disease Control, it has a recommendation that individuals, regardless of vaccination status, wear face coverings in indoor settings. So where a business is relying on that guidance, or again, their own health professionals, and saying that in order for us to provide safety for our staff and as well as the customers, clients that we're serving, we're requiring face coverings in our buildings or facilities. So it isn't necessary, in terms of the ADA perspective, for a face covering policy requirement to fit into the context of a necessary safety requirement under the ADA. A state may not have that face cover requirement, but a business could be relying on other reliable medical information to implement their policy.
The next question is, does the working dog requirements also apply to businesses like salon, barber shops, who required to post, quote, "no animals allowed" on the door? Peter's our resident service animal guru, so I'll let him take this one.
Yeah. So it is considered a modification to policy, practice, and procedure. There are limited areas where a service animal who is accompanying a person with a disability can be excluded. First thing I should say is that it's the person with the disability that has the right to be accompanied. Service animals themselves don't have any rights. Hopefully my guide dog Lloyd is not listening. But there are certain, so in a healthcare setting, a service animal could be appropriately excluded from a surgical suite or from an infectious disease area of a hospital. In a restaurant setting, let's say a restaurant, as part of their services, they people can book reservations and they get a tour of the kitchen. It may not be appropriate to have a service animal in that particular area. But in general, a person who is being accompanied by their service animal should be allowed to go, wherever the general public is allowed to go.
Okay. Well, at this time, I don't have any more Q&A, but Tammy, do you have any questions for us?
Well, thank you both for your presentation, and
I do have a couple more things to go over. I just wondered if you had any Q&A.
okay. Well, how about I wait until you go over those things?
Okay.
Because maybe what you're going to go over might be one of my questions.
Okay.
Okay.
So we'll just share a few more things with you, and then we'll do any more Q&A at the end. So if you at the end didn't get a chance to ask a question, or later on you think of something, feel free to email one or both of us. Our emails are on the slide. And again, we'll be emailing Tammy the PowerPoint presentation. We also do lots of free webinars. The one that we do a lot together is the ADA. Well, we do a few, but one is the ADA Legal Webinar Series. And it's a collaborative training program between our Great Lakes ADA Center and the Southwest ADA Center. Sessions are really intended to support continued learning and focus on the knowledge that you might have already gained since the implementation of the law, in terms of how the federal agencies and the courts are actually interpreting the law and subsequent regulations. And so the next one is September 22nd, and the topic is COVID and the ADA. And you can register at www.ada-legal.org. Then we have our ADA audio conference series, which has been the longest standing series we've had. And it provides a lot of different information over the ADA. And the next session is October 19th. And the topic is workers with long COVID-19 and ADA accommodation process. And you can register for that one at www.ada-audio.org. And now we have a new one. We have a new subset of our ADA audio conference that we're debuting next month. It's called Ask an ADA Professional. And during this session, individuals will have the opportunity to ask our ADA professionals like Peter, who answered the TA phone lines. And our first topic on October 13th will be hybrid work, face coverings, and vaccinations. And so it's really just people asking questions. There's no presentation. It's just asking all the ADA professionals questions. And you can also register for that at www.ada-audio.org. And then lastly, if you want to learn more about disability access, you can visit our Great Lakes ADA Center website for technical assistance, information, education, training, and we have lots of other resources such as legal briefs. You can always call us free for technical assistance at 800-949-4232, and you'll typically get Peter, and if he's off, you'll get me. You can always also visit our Accessibility Online Training website for listing of our free webinars I just reviewed. And don't forget to follow us on social media. We have an account with Facebook, Twitter, Instagram, or LinkedIn. Our handle is at ADA Great Lakes. And we post ADA tips, accessibility fails. We post announcements and resources, updates on any regulations, those type of things. We do hope that you found today's session helpful. The last few slides, which I'm not going to share, list other resources you might want to look over. That will be in the PowerPoint handout that I'll email to Tammy after the session. So that's pretty much what we wanted to cover. Any other questions or thoughts that people wanted to share?
Okay, well, thank you for that, and thank you again. One of the things that I wanted to ask, under that list of, I guess, reluctancy, where the list of where people were reluctant to take the vaccine, have you guys heard the argument about people being naturally immune to COVID, and that's why they're also not wanting to be vaccinated? Have you guys heard that at all?
I haven't. Have you, Peter?
I don't think so.
Well, actually, as I say, that's kind of been one of the arguments around here, is that some people are saying that they, and I think it's because they've been, probably asymptomatic or some kind of way exposed to COVID. And so, but they didn't get the full effect of it. So then therefore now that their bodies have built up the antibodies. And so they don't want to get the vaccine because they feel like, they've been exposed to it, or they had it, they beat it, and that's that. So I was just curious if your group had heard that argument yet.
Yeah, no, in this is ever changing, right? I mean, even though it seems like it's been going on for a lifetime, it is still very new, and things are research information is, being discovered, every day, regarding COVID and the virus and how it spreads, and what people have in terms of natural immunity and how long the vaccines last and whether or not we need boosters.
Right. And so, and just to comment on, some of the information that you guys shared, I'm very thankful that you guys were here today and had this discussion with us, because, around, here where I'm from, there's been a lot of conversations about, these masks and how they adversely impact those with disabilities. And so to learn, your perspective and better learn how to handle those things, because what we don't want is, for people to think that, those people with disabilities that, we don't care, we're not concerned, and no one is there, fighting for them for their rights, when they hear, information that they too have to, wear a mask and so on and so forth when, while this pandemic is in place. So, hearing you guys, go through this presentation and explaining all that, it helps us, or I feel it better helps me to, explain to them, why this is in place, why they need to comply, and also why, these businesses and other entities need to go, like you said, through that interactive process to find alternatives on how to deliver services and uphold safety. And that balancing in these times have been, or at least I found it to be very, very difficult. So I'm very thankful for your presentation today. I think that helps me out a lot in dealing with some of the things that's coming up around here. And I think someone now has put in another question over there in your chat box.
Yeah, so Peter, the question is there a possibility of getting a copy of these informative slides? Yes, I'm going to be emailing Tammy after we end our session, the handout for this slide presentation, so she can then disseminate that to the rest of you.
All right. Are there, I don't think I see any other, questions here. So,
Thank you, Tammy, for the opportunity, and thanks for everyone for participating today.
Yes, thank you so much. We appreciate it.
thank you. And I think what's going on here is that you guys have given out so much great information all at once. And so there's this incredible, processing that's going on. So I think that, you guys will be probably receiving lots of emails.
That's what we're here for.
Yeah, once all this stuff, sinks in, as well as, thanking you for providing your slides so that when people kind of walk back through those slides, ask questions, come up that way as well, they can reach out to you. Plus, this session as well had been recorded, so people will be able to go back and pick up on that information as well. And like I said, that too will provide an opportunity for some more questions to pop up. So with that being said, Marcy and Peter, again, we just thank you for being here. Thank you for the resources and all of the information. And I also want to extend to the both of you an opportunity to come back to the consortium during our June 2022 annual conference. We would love to have you guys there doing this presentation again. I'm sure there'll be some updates, some tweaks made to the presentation, but would definitely like to have you come back during our June 2022 annual conference. And then also last point is that from right now, September to December of this year, we're doing these educational sessions. And so we've got some that are booked out. I think October is now covered. We may have one or two, I think just one in November. So with that being said, if you guys have other information that you would like to present, please let us know, and then maybe we can get you guys in for another session during our, I call it the fall educational session.
Sure. Well, we're happy to cover Title I of employment too, because there's lots of different things in the world of employment, and we cover those things too. So if you want to do a session on employment with COVID, we're happy to do that as well.
Okay, so let's make that a date, right? Let's make sure we get you on the schedule for that.
Tammy, more importantly, let's hope that the June 2022 session is a retrospective on the COVID-19 virus.
Yes,
not ongoing.
Yes, thank you for that. I'm with you on that, and yes, I hope that is the case. So thank you very much. And that invitation, Peter, that was to both you and Marcy. So you're not off the hook.
Let him be.
Okay, I was gonna say just in case he thought.
I was gonna say Marcy was quick to accept on my behalf.
Well, that's great teamwork, right?
Indeed, he does the same thing to me, so
Right. Well, good deal. So to all of our participants, I thank each and every one of you for being here today. Our production man who is behind the scene, the treasurer for the consortium, which is Ronald Mullins. He has been the production man. So thank you, Ronald, for your assistance. And the whole planning team, the original planning team for our annual conference has been the planning team for our educational sessions as well. So I want to say thank you to all of them, and again, all the audience. And keeping that in mind, and I'll let you go after this last point, on September the 24th at 1 o'clock will be our next educational session. That session will be about evictions and foreclosure prevention. And this will be, I think, very, very special in that we have Margie Rice, who's our secretary for the consortium. She's down there in Bloomington, and she and some of the judges and attorneys and things of that nature down in Bloomington, they have put together like an eviction mediation type of court. and they want to share with all of us basically how to put our own courts together so that we can help fight some of these unfair, evictions that are going on, and particularly with regards to COVID and I think many of us just have some situations going on with evictions anyway that happened long before COVID. But at any rate, the specific purpose of this one is to kind of help prevent some of those evictions that's been going on across Indiana. So again, Margie and her group will show us how they have been able to put their program together. And this is the Eviction Mediation Court. They'll share their documents and again, how to establish your own court if that's what your particular county is interested in. So we'll send that information out to everyone as well. Feel free to share that information with judges in your area that handle evictions, as well as housing advocates that are in your area. I think this is a great conversation and a great opportunity for all of us to work together. And a matter of fact, Bloomington will share their interlocal agreement on how their courts are actually working down there in Bloomington. So with that being said, you all be safe. Thank you for your time, your energy, and your efforts. And we will see you guys back here soon. And have a wonderful evening and be safe. And thank you all once again. Bye-bye. And Ron, I will call you here shortly. Thanks.
Okay,
All right. Thank you.
bye.
Bye-bye.